Good morning, everyone, and welcome to Money Talks with Attorney Coral. I am Attorney Coral Ples, the host of the show, and thank you so much for joining us. I just want to give a special thank you to everyone who came out last week, Thursday, to celebrate the centennial anniversary of Columbia Savings and Loan Association. As you guys all know, Columbia sponsors the show for us every week so that we can provide financial information to the community. The show is educational, even though I'm an attorney. We are not offering legal advice. What we're doing is offering information so that we're teaching tools so that if you have questions, you can call in or information if you'd like to add. So thank you, everyone, again, for making the Centennial such a successful event last week. Actually, the two ladies that I have that are seated to my right in the studio this morning were a part of that. These are the world's most wonderful paralegals. Angelina Ravello Harrell and Kelly Yeager. Hi, guys. Welcome to the show.
Hi, hello. Coral.
So I've had the pleasure of working with these two for a number of months. And people ask me all the time, how in the world do you spend so much time working with Columbia Savings and Loan and manage to maintain your own law practice? And I say, easy. Angelina and Kelly. That's how I do it. So yeah, we're going to talk quite a bit about what they do, the business that they have, the services that they offer. And yeah, you guys, I would like to give you a chance to just say hello, introduce yourself, and just say hello to the audience.
Hi, I'm Angelina. Thank you for having us here.
I'm Kelly Yeager. Thank you, Coral.
Oh, thank you both for coming. So you ladies own your own business, A&K Experienced Paralegals. Is that right?
Yes, that's correct.
Okay. Angelina, tell us a little bit about the business in terms of what you do.
So Kelly has 27 years of experience and I have 18 years of experience. We have a combined 45 years of experience together. Me being bilingual and helping the Hispanic community is like a big thing for me. As well as Kelly has experience in like elder law and probate. Our business, we've decided to do the business. We've had the business for 2 years, and we've decided to do the business to help the minorities. We found out that within the 2 years that we've had the business, that minorities think that life insurance is enough, and it is not. You also need to have an estate plan to avoid your assets to go into probate. So we do estate planning, we do business LLCs, we do notary services, we do freelance paralegal work under attorneys, like we do for you.
Thank you for that, by the way.
And then not only that, but like more than anything, we're just here to serve and educate the people about having an estate plan. One of the things that makes our business unique is we make the client, we're more hands-on, and the client feels comfortable and we come to them if they're unable to come to our office. Even though we have a location in Brookfield, Capitol and Calhoun is the location of the office. We make it convenient where we would go to the client if need be.
Well, and I really enjoy the fact that you're bilingual because there were, probably a dozen or more clients right now that I would not have been able to serve but for your ability to help me communicate with those clients.
Mm-hmm.
Right. So that's a very big deal.
Yes.
Yeah. Yeah. No. So thank you for that. That's something that in my mind makes you guys unique. So that stands out. You don't find that everywhere. You don't find that in every law office or paralegal services. You don't find that. And being bilingual, that allows you to serve a greater group of the public rather than just the English speaking people.
Yes, that's correct.
And the fact that we go to people also is something that if, a person needs a power of attorney or something and maybe is having surgery or something and we need to go to them, that just makes it easier for everyone.
No, and that's a good point, Kelly, because I know that you guys go to different customers or clients because I know you've run around for tracking a few of mine down, which that helps so much because it saved me some steps and it saved the time in mailing things out. Sometimes people just want to
Mhm.
see you come and grab something or drop things off, and your willingness to do that has made the difference in a lot of different cases. But you raised a really good point. Kelly, because if it's a power of attorney document, and we'll talk in a few minutes a little bit more about what those things
Mhm.
are, but if someone is incapacitated in some way, not mentally, but physically, if
Right.
there's some sort of limitation that maybe they can't drive right now, or maybe they can't walk up and down stairs right now,
Mhm.
that it's an extra service above and beyond what a lot of professionals do. The fact that you guys are able to get up and just jump in your car and go and help people in
Right.
that way.
Right.
Yeah. So you mentioned that you've had the business for a while now, and you talked a little bit about some of the services that you perform. I think you talked generally about estate planning, which is what we're going to focus on more today. But you mentioned notary services, general forms and notes, business services slash LLC, and other additional services.
Yes.
Mhm.
So what I'm going to ask you to do right now is give out your number for your business, because what I like to do is make sure we give it out a few times throughout the show. But go ahead and tell people that if they need particularly estate planning services or any of the others that we mentioned, how do they reach you?
You can give us a call at 414-313-6625. Again, that number is 414-313-6625.
Thank you. Okay, guys. So if I'm a customer and I just heard a client, I don't know if I'm at the bank or if I'm at the law firm.
It's
I've
okay.
got customers, patients, clients, and I get it all mixed up. So forgive me for that. So if someone reaches out and let's say they just heard you give the number on the show,
Mhm.
and they call up and they say, "Okay, um, I'm a female. I'm, 40 years old. I'm divorced. I've got a couple of children. I want an estate plan." What would be, or maybe you know what? Because I'll bet you people don't say that. I'll bet you people call up and say, "I need a will."
Right.
Isn't that what people
Yes.
are more likely to
Yes.
say?
Yes.
Yeah.
Mhm.
So what are the first steps? First of all, once you hear from a person and you decide that you're going to meet, and keep listening, audience, because before we go to the break, I am going to tell you how to get a free 15-minute phone consultation. We'll get to that. I'll tell you what you need to do in order to have that with these ladies. But if someone calls and it's a question for either one of you, whoever is comfortable to respond, what's the first thing that you do once you're sitting there with the client?
Like to schedule the appointments or like when
Yep.
they just call?
Yep.
So
When you're
like
at the appointment.
I schedule the appointment and I tell them if they want me to email info sheets, or if they want me to mail it. Normally, like we either say, do you want to do it in person, virtual, or over the phone? A lot of people want us to like meet halfway, so they'll pick a location. One of the locations, another location that we meet at is like El Tanapa, which is my cousin's family-owned restaurant. So
Shout out to El Tanapa.
who
They,
supports our
they've, been, they've
business.
been good to us.
They have.
Yes.
Hello,
Um,
cousin Victor.
Yes. And so there, or otherwise we go to their house or we meet at a Starbucks or something. Sometimes they'll complete it or they'll get very overwhelmed, and they won't complete the info sheet, which is fine. But then basically we meet and we give them the information, and how based on their assets and stuff like that. And we take some information down and we tell them they can move forward with us and stuff.
Okay. So what sorts of questions are on the info sheet? Like if someone's going to meet with you, what type of information might they be asked to provide? Just in general.
Sure. Their basic information like their name, children's names, address. Um, and then we would like to know who they would like to name as the executor or trustee of their trust,
Hmm.
personal representative of their will, their powers of attorney, agents, just basic information.
Okay. So when a client comes in and they tell you what they think their needs are, right? Do
Mhm.
you sometimes have to say to them, you know what, this might work for you, but here's a recommendation to maybe do something a little bit differently. So let's say if someone comes in and they're asking for a will and you think they might benefit from having a trust, do you have some discussion with them about that?
Definitely. We want to make sure that they get the documents that are needed for their situation.
Right,
Mhm.
right. And then, of course, everything that you do as paralegals is under the supervision of an attorney,
Right.
in particular, when we're talking about estate planning documents and those sorts of things.
Mhm.
Kelly, you and I have come and we've sat at the office together and we've had,
Right.
an initial meeting with one potential customer in particular who
Mhm.
was interested in trust, so that the attorney's right there to provide whatever appropriate oversight that's needed for it. But you guys are seasoned, so you know what questions to ask to get people thinking.
Right.
Right.
Under your direction. Yes,
Right.
of course.
Right,
Mhm.
right. Yeah,
Mhm.
yeah, yeah. So with that support, um, sometimes, well, let's talk about this. Even before I get to that,
Mhm.
um, is there, in your experience, um, is there a dollar limit that people have to have before it's advisable for them to have a trust? I know that sometimes people will say, "Oh, I'm not rich. I don't need a trust."
Mhm.
Do you have to be rich to need to put your belongings in a trust to safeguard your
No,
property?
no, not at all. Not at all. Um, it's better to have a trust because it avoids probate, but I think we're going to get into that a little bit more, right?
Right, right, right. Yeah, no, that's fine.
Okay.
That's fine.
And
Okay.
yeah, and I mean, we've done estate plans for kids that are in college. Their parents have decided to do an estate plan for their kids in college. They're 18. Once they're 18, they're considered adults. So that's another thing we stress. Maybe you want to do powers of attorney for your kids if they're away in college, like financial and healthcare. If something was to happen to your kid outside of in college, you're their parent, but again, they're over 18, so they're considered an adult. And so we've done that, and we've also done like trust. Parents have decided they might not have anything, but mostly everybody that's in college tries to have a trust. Like a lot
Yeah.
of people have trust.
And I don't want to forget to mention what you just said, and we'll circle back and talk a little bit more about the trust versus will, and what is a trust and all of that. We'll get back to that, but you just said something important that, Kelly, I think you and I talked about a few weeks ago,
Mhm.
and we talked about mentioning on the show with respect to how you protect a college kid. Can you say that again, Angie, and just make sure that everybody caught that?
So if you have a child that's all off to college and they're over 18, it's important that they have like a financial financial power of attorney and a healthcare power of attorney, because if anything was to happen to them, you would need to have you as a parent, you're their parent, but they're over 18, they're considered an adult, they're no longer a minor.
Mhm.
So you would need to get that information and have that set for them before they go to college and stuff like that.
Mhm.
Okay. So yeah, so it might be important then for those two documents that you mentioned, the healthcare power of attorney and then the
The
general
financial.
financial power of attorney,
Mhm.
to have that in place because they are technically, legally, they are adults at that age.
Mhm.
Yeah, yeah. So no, that's a good point. Um, okay, so let's talk a little bit about the other, just maybe a listing of the different types of estate planning services that we're able to offer. So we talked about trust, and we'll come back and talk about that a little bit more. We talked about wills. Um, what else is there?
The financial power of attorney and the healthcare power of attorney, as well as the deed to the property. So any property you own in the state of Wisconsin, we would also need to protect from probate as well, and would be going into the trust.
Okay.
If they own LLCs, we do an assignment of LLCs. If they have the stuff for the grave, for the funeral stuff, like the grave, like the plots and stuff, we do an assignment of lots and stuff like that with that information that will also be going into the trust.
Okay.
Mhm.
So what do you mean by assignment of those particular documents? Assignment of deeds. So who are we assigning it to? Assigning it to the trust?
To the trust, yes.
Okay. Okay.
Mhm.
All right. So no, so that makes sense. All right. So you do a lot. You provide a lot of different services, a lot of different options. I know that I've had several shows, but one in particular that I spent the whole hour just talking about power of attorneys, because
Mhm.
any one of these can just get, deep. And then there's even many types of power of attorneys. You mentioned the two, but with the financial power of attorney, then there's subcategories even there. So I spent a lot of time on the radio, even just talking about that and explaining, just explaining to people. And one of the thoughts that I had with respect to that, and I want to see what you guys think, and based on your experience, the power of attorney document um, sometimes is an afterthought for people,
Mhm.
but I actually think that it is really important, and maybe even in some ways more important than, let's say, even a will. This is just my opinion, so I just want to know what you guys think.
Mhm.
But it's because the power of attorney documents affect what goes on with you while you're still here.
Mhm.
So
Right.
you matter, right?
Right.
So while you are still alive, and the power of attorney document says, okay, handle Coral's finances this way, or handle Coral's living, situation like this.
Mhm.
So I mean, it's actually a very important tool, is it not?
Yes.
Definitely.
Yeah. So that's
Definitely.
been you guys' experience too.
Mhm.
Yeah.
For sure.
Okay. So not just me. So we encourage people to seek out the assistance to put those sorts of documents in place, because it's
Right.
important stuff.
Right.
Yes.
Okay. So
Mhm.
before I forget, let me just give the number out here. If there's anyone that has questions with respect to what we're discussing, please feel free to give us a call. It is 414-444-5250. That is 414-444-5250. We'll get you through to us this morning if you've got questions about what we're talking about. All right, ladies. So moving right along, um, I wanted to talk a little bit today about having a trust versus having a will. But before that, will you, Kelly? I'm going to ask this of you to tell us,
Mhm.
what is a trust, and give us an example, something descriptive to explain what it is and how it works.
Sure. And we're talking about a revocable trust,
Yes.
correct?
Yeah.
Sure. So a revocable trust will avoid probate if it's funded properly. So the way I like to describe it is it's a pot. And upon your death, all of your assets go into the pot and it's distributed accordingly to your wishes and your trust.
Okay. And when you say revocable, that means you can pull it back.
We can pull it back or make changes to it or amendments.
Okay.
Mhm.
Okay. All right. So
Mhm.
that's good to know.
Mhm.
So yeah, so maybe people get the visual then, that, with your pot analogy. I like that.
Mhm.
So I wanted to be sure that you talked about that a little bit.
Sure.
Okay. So from what I understand, and I've printed out some items that I think are positive when it comes to having a trust.
Mhm.
And then I'll just mention it. If you'd like to comment or agree, or even disagree, that's fine too. Um, so trusts are beneficial because, one thing, it helps you to avoid probate.
Right.
Mhm.
Okay. Can you talk about that a little bit? Like, what does that mean, to avoid probate? To just not have to go to probate.
Not have to
Right.
go to probate, right? And
Mhm.
probate is a court process. So you have
Mhm.
the time limit. It takes time to get your assets, distributed to your heirs and beneficiaries. There's a cost to it. Not only normally attorneys' fees or paralegal fees, but there's also court costs,
Right. So time and money.
time and money.
Yeah, two of those
Mhm.
things that we like to conserve.
Right.
So, how about asset protection? A trust can protect your assets, sometimes from lawsuits and creditors. I know that's not 100%, because there's
Right.
exceptions. There's ways to get at things, but
Right.
that's one of the reasons for creating a trust.
Mhm.
True.
True.
Yeah. Um, how about flexibility? A trust can give you more control over your assets than a will, including when and how beneficiaries will receive the assets.
Sure,
Right.
especially minors. So if you have a minor and you don't want that minor to receive the money until they're 25 or 30,
Yes.
they would have a trustee named for them prior to that age.
Okay, so that makes sense, and that would be a really good reason to
Mhm.
consider putting things in a trust.
Mhm.
Okay, so Jermaine is queuing me up with the music, and he's so subtle with it, but I caught it. All right.
I was like,
Thanks,
oh.
thanks,
Yeah.
Jermaine. All right, so We're going to take a break now, but when we come back, there will be more with the A&K experienced paralegals, Angelina and Kelly, whom I'm delighted to have in the studio this morning. And we will let you know how you can get a free 15-minute phone consultation with either myself or these nice ladies. Okay, we'll tell you when we come back from the break. Thank you. Welcome back to Money Talks with Attorney Coral. I'm Attorney Coral Plez. Thank you for listening this morning. Our show is sponsored by Columbia Savings and Loan Association. I'd like to remind everyone to reach out or stop by Columbia and apply for a mortgage loan. We are set up to operate and to take care of business, and we look forward to hearing from you with respect to any mortgage loans that you'd like to apply for Columbia Savings and Loan Association. I'll give the number again at the end of the show because I don't know my own mother's phone number. It's 414-374-0486. That is 414-374-0486. Sorry, my mind did a thing on me there for a second and I just could not think. Please call Columbia for mortgage loans. If you would like to apply, give us a call and arrange an appointment to come in and meet with our brand new loan officer. All right, so I have Angelina and Kelly in the studio with me this morning. They are the proud owners of A&K Experienced Paralegals, and these two ladies have a wealth of knowledge and experience when it comes particularly to estate planning. And so please tell people how to reach you again before we go into the next line of questionings. Give your contact information.
So it's 414-313-6625. Again, that number is 414-313-6625.
Okay. So before we went to break, we were talking a little bit about the benefits of having a trust. And so one of the next points that I wanted to talk about a little bit is a good thing about a trust is that a trust is private. So Kelly, tell us a little bit about what that means and why that's important.
Sure. The trust is not does not have to be recorded anywhere. So the privacy is important because it doesn't show up anywhere. So if you have your wishes in a revocable trust, it's your document. The only one that's going to know about it is your heirs and beneficiaries, your trustee. We also do what's called the transfer on death deed for property that goes along with the trust. The trust is the beneficiary of that document. It's recorded with the Register of Deeds. However, it doesn't show up on the record until death. So it's completely off record. It's not going to show on your property tax bill. It's not going to show if somebody looks up your property address. So it's completely off the record. So privacy is huge with a trust.
Right. And I'll bet a lot of clients, would value that because people value their privacy. Now, that's unlike a will, which does become a public document when it goes through probate. True?
Yes,
True.
that's correct.
Yeah.
Right.
Yeah.
And people can go and, look that up and it's recorded at the Register and Probate Office.
Right. Right. And I know you just mentioned the notion of a transfer on death deed. Tell the audience a little bit, either one of you, what is a transfer on death?
So we prepare a transfer on death deed. That deed is the trust is the beneficiary of the deed. And it is recorded with the Register of Deeds. But again, it does not show up on the record. It's not part of the title until the person passes away.
Okay. So it is really just kind of what it says it is, that it transfers the property upon the death of this person.
Right.
Yeah.
Right.
And in the instance that you're talking about, that the trust is the beneficiary. So once that person passes away, the trust, the deed to that property is transferred to the trust.
Yes,
Correct.
that's correct.
Okay.
Correct. And then it would be distributed according to the wishes in the document,
in
the trust document.
Right.
Mhm.
Right. So another benefit, and we won't get deep in the woods on this because this is not an area of my forte, but tax benefits. A trust can provide certain tax benefits just in general. I think
Right.
that's a good understanding.
Right.
And the control, just being able to have control over who receives your assets after you die, and when, because
Right.
you gave an example, I think, when we were on the break a little bit, Kelly, when you talked about, well, especially if there's minor children and you can, I don't want to put the words in your mouth, but tell us what you were explaining with respect to a trust, how you can have some control even after death if you want to make sure that children don't come into money or assets or anything before they're ready. So talk about that a little bit.
So within the revocable trust, if there are minors, you can set it up so the money's distributed at an age where you feel the child's going to be ready. Could be 25, 30, whatever age you choose. And then they would name a trustee of that money until the child reaches that age. Another thing in the trust is the ability to name guardians of the children. So not only would you have trustees of the money, you would have guardians of the minor children until they reach the age of 18.
Are those usually the same person, or is the trustee over the money with the children usually a different person than the guardian, just in your experience?
Sure, I would say normally it's the same person. It's the same person. The guardian's taking care of the minors, so it just makes sense to have the same person as the guardian of the estate or the money of the minor child.
So when you set up a trust, do you normally have more than one trustee, or how does that work?
Yes, and we usually recommend that. We could do co-trustees, so there could be more than one acting at the same time, or we at least would like one plus a backup. And with a revocable trust, you're in charge of your own assets while you're alive and able to. So you want to name someone that is close to you and that is trustworthy to handle your estate when you're unable to.
Well, I think you just said something that's really important. That, well, a couple things that are really important that you
Mhm.
just said that I would just like to emphasize. First of all, it's important to let people know that when there is a revocable trust, they are still in charge of their own assets.
Mhm.
True.
True.
That's correct.
Yeah. So
True.
it's important to, I think, just underscore that, because
Mhm.
I think what makes people sometimes hesitate about getting a trust is they think, well, once I transfer my assets out of my name, then I'm not in charge of anything
Right,
anymore.
and that's not true.
Yeah, yeah,
That's not true. They have complete control. And that's why we also practice to make the trust the beneficiary of the assets, not retitle or anything, so that they still have the control until death.
sure. Okay.
Mhm.
And then that makes sense. That
Mhm.
makes a lot of sense what
Right.
you just said. The other thing that you mentioned that I think was really important is to choose someone that's trustworthy, somebody
Mhm.
that you know, because you're
Mhm.
really giving them the power to manage your affairs
Right.
after you're gone,
Right.
right?
Right.
So, what about, okay, you talked about sometimes having co trustees. Have you ever had a situation that's been problematic, that maybe you've got two trustees and they're thinking in different directions and they don't agree on things? Has that ever come up?
Absolutely. We've had it where we've had 3 trustees, which was basically a nightmare. 2 2 is bad enough, especially like if they're out of state or something like that. They need to do everything together. So if you want co-trustees, you really have to think about it. A lot of people like to do, if they have 2 kids, they like to have both of them co-trustees, which sometimes works out fine. But they have to be at the same place all the time. They have to both sign the checks. They have to be in complete agreement.
Okay, so that you may have answered the question, but I'm going to ask it anyway. So let's say if you've got three people
Mhm.
and two of them agree on something and the third one doesn't,
Right.
do the two overcome that third one, or they all three have to sign and agree?
They all 3 have to agree.
Yeah, otherwise
So
it goes before the
it
court.
goes before the
Yep.
judge, right? And
And
we've seen it happen. We've seen it happen with 2, with just the co-trustees.
mhm,
But some people just want, they're comfortable with it, and sometimes it does work.
mhm.
You know.
Yeah. I know sometimes I advise people to just pick one person
Mhm.
and pick a backup for sure,
Mhm.
right? But
Mhm.
a lot of times parents will come in and they'll say, "Yeah, but I got a son and a daughter."
Right.
And she's more responsible, but he's the older. So
Yeah.
I feel like it'll feel bad if I don't
Yes.
put him in there.
Mhm.
Or he's more responsible, but she's the elder. You know what I mean?
Right.
And then they kind of go back and forth with it, and I pick the most responsible person
Mhm.
whose judgment you believe you can trust.
Right.
And people get upset, let them. And yeah,
Right.
we just
Right.
kind of go from there.
Right. With the financial power of attorney, we do or a lot. So if we're naming 2 people, we put the or in the middle, so either one of them can act instead of acting together. The other thing would be with the co-trustees of a trust is if something happens to one of them, then the question is, can the other one serve alone then, or do they want another backup to that?
Oh,
So that's where it can get, a
A
little
little tricky.
tricky.
right, right.
Mm-hmm.
Yeah, that's a good point. I hadn't thought of that one.
Mm-hmm.
Okay, well, I see that we have a caller holding, and I'm gonna go ahead and say, caller, please. Oh, it looks like we lost the call. Okay, yeah, nope. I saw a call holding there for a second, but Kelly was giving such great information that I didn't want to.
She
I
was on
didn't
a
want to cut
roll.
her off, but okay. So, but the caller. Oh, there we go. It looks like the caller's there for us. Good morning, caller. Go ahead.
Good morning, Attorney Cora. How are you?
Oh, I'm doing well. How are you
Blessed,
today?
grateful, thankful to the Lord. Tyrone W. speaking. Good morning, ladies in the studio, the guests.
Good
Good
morning.
morning.
Good morning, Mr. Rideout. Good morning, Mr. Carvey.
Good morning there, sir.
Yes, sir. Good morning, Milwaukee. And the new one, L, Mr. L.
Good morning. Good morning. Good morning. Good
Yes,
morning.
sir. Good morning. Just a quick question there on what you're speaking about. You was talking about the trust and the wills there, and I was curious, very curious, almost like Curious George. And I read all those books. and if you could just comment, would multi properties apply to what when you're talking about the wills and the trust? I mean, how does that shape up? And what does that look like when multiple properties come into effect or into view? Then, and I'll listen to you over the air. Then, thank you very much. Thank you.
Okay, thanks for calling. Okay, so did you guys hear or understand the question? He's saying that if there's someone who has multiple properties,
Mhm.
can you still work with a trust, or
Absolutely.
how would you do that?
That
Okay,
is a
Very-
great reason to have a trust
right.
to avoid the probate and to make sure at death that those properties get distributed how they want it to be
Okay,
done. Yeah.
so
Yeah.
just in general, what steps would you take to protect those properties, or excuse me, yeah, properties in a trust?
We would basically do the transfer and death deed like we talked about before.
Hmm.
When we do the trust, because normally if a property is over $50,000, it would go into probate if nothing was ever drafted.
Okay.
And then nobody could sell the house or basically do anything with it because of the fact that nothing was drafted for their estate.
Okay, and that would be an example of a time when you would do transfer on death, but you'd make the trust the beneficiary of
Mhm.
that property.
Yes.
Which, go ahead, Kel.
Yeah. Having said that, if they want a specific person upon their death to get the property, we would put that in the trust.
Mhm.
So they would be getting that property, but the property would still be transferred on death to the trust, if that makes sense. So it would say specifically who the person is in the trust getting that property instead of giving it to the person now.
Okay, so would you say that just based on your experience over the years of preparing trusts, are they unique to the individual? You have to do different things depending upon what types of issues or concerns the client has?
Yeah, so
Yeah.
just like what we talked about, if they have a specific property that they want to go to a specific person, we would put that right in the trust. We also have a specific gifts page that's attached to the trust, that can be filled out at any time. So if they have jewelry or art collection or something like that that they want to go to a specific person, a grandchild or something, they could fill that out at any time. It just needs to be signed and dated, and then it becomes part of their trust document.
Okay. So once you have everything compiled for an individual's trust documents, you let them have an opportunity to review it, or how do you go about getting it into their hands?
So basically, we either ask them if they want it to mail or we want to email it to them, and then we send it to them, and then we'll give them a couple weeks, and we'll let the client know that it's in the mail. The drafts are in the mail. Normally, we send them out within a week of after the meeting, right away. Give them a couple weeks to like look everything over. We know that there's going to be questions and stuff, and that's mostly common because there's a lot of like legal language and a lot of other stuff that they don't understand. But more than importantly, then we follow up and we want to make sure that it's to the way that they want it, and it's written up from the meeting in our notes. There's perfectly fine. That's why there's drafts if they want to make changes. During the second meeting, we do another meeting just to make sure that they understand. And if there is changes, we'll make those changes, and then we'll just schedule a final appointment to do the signing. Whether it could be at their house, then we bring the witnesses and the notary, or they come to our office. But then once everything is completed, we give them an electronic copy for their safekeeping, a binder that every has copies, and we give them originals for them to keep in a fireproof safe. Then we give them a letter just to tell them on how they should fund their assets moving forward, any bank accounts, any retirement accounts, life insurance. So it all stays in the pot, like Kelly spoke earlier. It's all protected under the trust, all their money assets.
Okay.
Mhm.
Yeah, I was going to ask you to talk a little bit about funding of the trust. But before you do, I like what you just said about the steps that you take to make sure that the client has an opportunity to review, an opportunity to sit and ask questions because there's legalese and all of that that may not be apparent. So people
Mhm.
get all of their questions answered then before everything is finalized,
Mhm.
right?
Right.
Yep.
And this is you mentioned that if you visit them at their home that you'll bring the necessary witness or a notary,
Mhm.
or they can come to the office and then it can all take place there as well.
Right.
Yes.
Right. So, and you mentioned about a fireproof safe. Is there like a list of instructions or something that you give people at the end, or even just verbal instructions to say,
I give
hey,
them
keep
verbal
this safe?
instruction. Yeah, I give them
Mhm.
verbal instructions, but we do like a follow up letter just to make sure, like
Mhm.
after like a month or two, to make sure that they made sure that they put all the stuff into the trust. It's like a friendly reminder letter that,
Right.
hey, you signed your trust on such and such day, just making sure that you followed up and did all the funding to the trust and got all that taken care of. And
Mhm.
mostly they'll say, oh yeah, we did, or
Mhm.
oh no, you know what, I forgot to do
Mhm.
that. So
Give us an example of what it means to fund a trust. Hold that thought because I don't want to lose the caller that's holding here.
Okay.
We'll circle back to that. Caller, thank you for calling. Go ahead with your question.
Yes. Good morning to you and the staff there. What is a wet signature? And I'm going to hang up and listen.
Okay. Um, I think I have an understanding of what is a wet signature, and you guys can jump in if you think anything other than that. But a wet signature is an original signature. It is not a copy, it is not a scan, it is an original signature.
Right.
Is that
Right.
is that your understanding
Yes,
as
Yes, it
well?
is.
correct.
Mhm.
Okay. Looks like we have another caller. Thank you, caller. Please go ahead.
Yes, I was trying to get the contact information.
Oh, okay. Well, thank you so much for that. We're going to go ahead and I'll ask Angie to say it again if you're ready to write, and we'll make sure we mention it yet again before the end of the show. But go ahead, Angie.
And
Then
then one last thing.
Yes, please.
Can you also discuss how a trust can work for when you have a parent that's a senior, before they need Medicare or Medicaid?
Okay. Um,
Do you understand the question?
So some pre-planning.
yeah, pre-planning.
Yes, ma'am. Thank you. And I'll hang up and listen.
thank you so much. Okay. So first, if you give your contact information again.
414-313-6625. Again, the number is 414-313-6625.
Okay. And we'll say it yet again before the end of the show. This is A&K Experienced Paralegals, Angelina and Kelly, and at the number that Angelina just gave. So that was the first part of the question. And then there was a question with respect to pre-planning for parents. It was kind of a general question, but just, give some idea of what that might look like.
It all depends on the assets that these seniors have. There's different tools that can be used for pre-planning. I'm not sure a revocable trust is the best idea. There's an irrevocable trust and some other things, but it all depends on the situation.
So most likely then I would recommend for the last caller that if there's more details or specifics or specific set of facts or circumstances that you're working with, please don't hesitate to reach out for a phone call. I was supposed to tell everyone how to get a free telephone consult, and I didn't do that. It's easy. Just mention that you heard about us on WNOV radio. When you call, mention that you listened to the WNOV show, Money Talks with Attorney Coral, any one of those things, so that the ladies will know that the call came in from the show, and you will get a free consult, 15 minutes, either with Angelina or Kelly or myself or all three of us. I don't know. Just we work
We all work
together.
together.
Right.
Yes.
We work together with respect to all of this. So I appreciate that caller so much. But it sounds like that might be a person that might need to just go ahead and give us a call directly and take advantage of the free consultation.
Right.
So please don't hesitate to give us a call. Just for clarity's sake, Angie, give the number one more time.
414-313-6625. Again, that number is 414-313-6625.
Okay, thanks for that. Okay, so before we took the phone calls, we were talking about funding of the trust. You were describing just the process of what we do once everything is complete and signed off, and that you send a follow-up letter 30 days later and say, hey, just checking to make sure you guys
Yes.
funded your trust.
And I do follow up. That is.
Does she ever? Yeah, she keeps me on my toes following up. But that's what that's what every attorney needs, and especially when you're as busy and as loaded with things to do as I am, and it keeps you. I mean, you're walking a tightrope, and you guys are a safety net, and that just and you're just above and beyond with what you do, and I really value you and appreciate you and commend you for all that you
Thank
do.
you.
Well, thank you.
Thank you.
But I do want to talk about an example of what it means to fund a trust. What would be one item that they may have to do a little work on to fund a trust?
First is it's important to fund a trust. If you want to avoid probate and you want it distributed according to your wishes, you have to put something in the pot. If the pot is sitting there empty, it's not going to do anything for you. So it has to be funded. And that's where Angelina comes in.
Okay.
With her
then
funding.
we would do. So it would be the bank, any like checking, CDs, money market, any brokerage accounts, any stacks, and then like the life insurance, and then like retirement accounts, 401ks or annuities or 403bs. All that stuff would need to be funded into the trust.
Okay,
If
but
it's-
let's stop right there, because I think that we're talking a little over people's heads a little bit. But it's so you do it every day, so you're just what you're saying.
Mhm.
I want to break it down, even
Okay,
like in
okay.
simpler language. So if, let's say, a person has a checking account, what do they need to do to that checking account to fund it into the trust?
Payable on death designation
There you
to
go.
the trust.
Right. Okay.
For
So
the checking, for any bank accounts, any CDs, it would be a payable on death designation.
okay.
And then for like any stacks or brokerage accounts, it would be a transfer on death designation.
Okay. And is that paperwork that you help them with, or do they have to reach out to the financial institutions for that?
We normally we can assist them, or they can get their financial institution or the financial advisor if they have one.
Okay, great. All right, that sounds good. And I hear the cue. Thank you, Jermaine, for keeping me on my P's and Q's. We have to take a break, but we will be right back with more Money Talks with Attorney Coral and the experienced AK paralegals, Angelina and Kelly. Welcome back to Money Talks with Attorney Coral. I have the wonderful paralegals Angelina and Kelly in the studio with me this morning. They are the A&K experienced paralegals that have been working with my law firm for a number of months, and I don't know how I get anything done anymore without these two. I mean, it matters not what it is, whether it was coming and helping to get the invitations out for the centennial celebration, to helping with the estate work, or even my litigation files. They're fearless. they jump in, and they are just an enormous support with each and every thing that I do. And it would not be possible for me to spend as much time as I am able to spend on site with Columbia if these two weren't handling things and taking care of business when I'm off site. So much so that Angelina now has my law office cell phone because I was having a hard time getting back to it and being able to answer. Legal work does take concentration, and I know sometimes that people would like to call and be able to get through to me directly, but it's just it helps to have the support so that I can really focus on the legal work and the court process and taking care of those things. And I wouldn't be able to do it without the support of these two. So thank you again, very publicly. I want to say that and let everybody know
Thank you.
Thank you.
that is a ringing endorsement because I've experienced it. So I do want you to give the contact information for your business again. And then after that, I'd like you to give some final words of wisdom, your advice as to why it is important to have an estate plan. Go ahead, Ange.
The number is 414-313-6625. Again, that number is 414-313-6625. And again, I just want to tell people that you don't need to have a lot of money in order to have an estate plan. We're just here to help people and get your assets in order, and it'll make it a lot helpful for your family and easier for them once you pass away. I know a lot of people say, oh, well, I'm not going to die right away or anytime soon, but you just never know. Tomorrow's never promised. So, it's good to have everything in order. And we're just here to help people and educate people and see how we can best assist you guys.
Right. And, it's not the end of the world if you pass away and you don't have an estate plan. But having said that, it's just easier on your family if you do. They not only know your wishes, how you wanted your money distributed, how you wanted your last days to be handled. It just makes it easier on everybody around.
Right. Right. I agree with that. And what I tell people sometimes, you pass away without a will, without a trust, or any estate documents. Don't worry, the state of Wisconsin will impose one for you, right, by statute.
Right.
Exactly.
and that might not be what you had in mind.
Mhm.
I know one of the prior shows I did, I talked about I have to say it this way, the late, the great, the honorable Mr. Prince Rogers Nelson. Number one
Right.
Prince fan
Right.
right here.
There you go. Yeah.
Ernie and I are always debating Prince, Stevie Wonder, Prince,
Right.
Stevie Wonder. I say Prince, of course. If he was here, he'd say otherwise. But Prince died, presumably intestate, meaning
Mhm.
without a will.
Mhm.
And that court battle raged on for years. It cost millions of dollars to litigate.
Yeah.
Right.
It is the lawyers who benefited at the end of all of that.
Mhm.
And, I, of all people, don't have a problem with that because lawyers work hard, right? And they do what they
Right.
do.
Right.
But I don't think Prince would have wanted to give his millions of dollars to attorneys as opposed to whomever he may have chosen
Right.
for his assets to go to. And in his case, from what I understood, his siblings became his heirs. His parents had predeceased him. He was not married. He did not have children and at the time of his death. And therefore, it was his siblings that inherited his estate. And they were not always on great terms. There had been litigation even between them. So who's to say that that's what he would have wanted?
Right.
So
Right.
that's
Right.
why it's so
That's
important,
important.
To do the planning. He was a young guy still, and yet, this terrible thing happened.
Right.
So all
You
your
just never
words of
know.
wisdom. Okay, A&K experienced paralegals, Angelina and Kelly. Angie, give the number one more time before we go.
414-313-6625. 414-313-6625.
Okay, get your free consult by mentioning WNOV, Money Talks with Attorney Coral, or anything referencing our show today. Thank you so much for listening. We'll be back next week.